Hey, so a question came in today, which is, what is the process for getting a patent? Hey, that's an awesome question. I love it. I'm going to break down the five main areas, the five big, huge process chunks of how to get a patent granted here in the US. So, step one, you got to invent. That probably goes without saying, but I want to bring it up. That is step one. You have to invent something. And what does it mean? Well, you have to come up with something that's never been done before, right? Ever in the history of the world. And you have to do something that cannot be as similar to something else done like it. So that's what's called non-obvious. So once you've invented something, part of the step one is doing some diligence, okay? Your own research. Go look online, use Google, use YouTube, take a look at publications in your industry. Make sure that what you've created, what you've invented, has never been done before. Okay. Step two is to go hire a professional, hire an attorney. They're going to be on your side, your guide, someone who's been in this field for many years, knows the law, understands what the USPTO, the patent office, is looking for. And so they're going to give you a patentability opinion. Maybe they'll do their own research, go look at the publications and patents that have been issued in that field to confirm, yeah, this is actually a great invention and you have a big scope of rights to go after. And step three is to prepare and file your patent application. This is all the written words and all the complicated legal claim jargon. This is what the USPTO examiners are going to review and make sure that this is indeed different from whatever has come before it, and what scope of rights, what they're going to allow, what claim scope they're going to give you if your patent does get all the way through the process. So step number four is that examination. So the USPTO, the United States Patent and Trademark Office, they hire examiners, and they've got hundreds of them. And so they spend, years in each specific technology art unit. So they understand the cutting edge, the bleeding edge, if you will, of every technology area. And so their job is to make sure that what you're claiming, what you've invented, is indeed different, novel, and is not the same or, similar to what's been done before. So it has to be novel and non-obvious above what's called the prior art, previously submitted patents or publications. And that can take a year plus, right, to get past that examiner. Show them either through legal arguments or through subtle amendments to the claims that now they're convinced that what you've invented is truly novel and non-obvious, and they allow it to be granted. Step five, you've made it. This is the patent grant. And now you get to decide whether you want to now pursue invention protection in other countries, if you want to now file what's called a continuation application, claim additional rights, divisionals, a lot of different things in this step five before that patent gets granted. And then you get to celebrate when that patent gets granted, and you now have the ability to stop anyone from making, using, selling, or importing your product to the US. So those are the big five steps. I'm excited to go through some of these steps, each of them, perhaps this week, in more detail, so you can get some more information about how to actually go do this, move forward with confidence, and perhaps use our attorneys here at Bold Patents to help you do just that. All right, everybody, have a great day. Go big, go bold.